Thank you, Mr. Speaker. It's rare, and members of this House will know it, that standing as leader of the Green Party of Canada and Member of Parliament for Saanich Gulf Islands, that I've not availed myself of the opportunity to present amendments at report stage, at committee stage, under new rules that were adopted last fall. As members will know, and as you would know, Mr. Speaker, I've objected to the opportunity because it hasn't amounted to a real chance to amend legislation. But nevertheless, I've gone forward to every committee on bills that I find disturbing with amendments of a substantive nature. And in the case of Bill C-36, I found I couldn't do it. I couldn't find a way to amend the bill in a way that could actually fix it. And that's why, Mr. Speaker, I appreciate you have now read out attempts to delete the entire bill based on it being unfixable. How do we find ourselves here, Mr. Speaker? Well, as we all know, the court ruled, in the Supreme Court of Canada, ruled in the Bedford decision that our existing laws relating to prostitution were unconstitutional and that they violate the Charter of Rights and Freedoms.
In Section 7 of the Charter of Rights and Freedoms, where we find this primordial principle for Canadians, and I quote, "Everyone has the right to life, freedom, and personal safety. This right cannot be violated unless it complies with the principles of fundamental justice." And the Supreme Court, in the case of the Bedford decision, found that this section of the Charter of Rights and Freedoms was not respected in the laws and in Canada's criminal code with regard to people that we call sex workers who are threatened by the situation of with the legal situation in Canada.
Laws relating to prostitution did not adequately protect the rights of security of the person for people who find themselves in this very marginalized and difficult place in their lives, that they were even more marginalized, even more stigmatized, and driven into the shadows by the status of laws over prostitution in Canada. It was to us as Parliament to come up with an approach that would respect and would protect and would ensure that people in the sex trade industry were not driven into the shadows. For myself, Mr. Speaker, I thought we would see in Bedford, after Bedford, a response from Parliament and a response from the Minister of Justice that took into account the message from the Supreme Court of Canada. Ironically, earlier this morning, Mr. Speaker, I attended an international symposium on the subject of gender, violence, and health. It's an international symposium taking place a few blocks from here at the Novotel on Nicholas Street, and researchers from across Canada are presenting research on this topic with people from around the world. It's a collaborative social science project in Canada on gender, violence, and health that was funded by the Canadian Institute of Health Research. And I was able to stay long enough before coming to the debate here on Bill C-36 to hear the preliminary findings of that work being done across Canada. I was pleased to see that members of, from my own part of the world, from University of Victoria, from the City of Victoria Police Department, had all participated in this work. Now, I have to say that their area of research was restricted to people in the sex trade industry who were over 19 and who were not part of the quite horrific trafficking in people who don't have rights. And I want to make it really clear that in the Green Party's stance against C-36, we believe the full measure of the law should be used to crack down on anyone who is exploiting minors, anyone who is exploiting people in sex trafficking. We believe laws in that area must be strengthened and that the laws are adequate, even as they now stand, to differentiate the situations between prostitution in general and this particular group of exploited workers under 19 or trafficked internationally who lack the rights that they should have under the law. The research being done, which is being reported on just today, as I mentioned, across the way there, but funded by the Canadian Institute on Health Research. Collaborative work in 6 different cities across Canada involving some of our best social science research. They examined the lives of sex trade workers who were not under 19 or involved in human trafficking. And what they found as a foundational piece of information in early research, and it's intuitive and it's what the Supreme Court of Canada understood. Any laws that are punitive in nature, anything that in our social context further stigmatize sex trade work, means that those people conducting themselves in that work are more vulnerable, less able to access the supports and protections in our society. So going from the Supreme Court of Canada's decision, it's pretty clear what Parliament needed to do. Parliament needed to find a way to ensure that people in the sex trade industry were not driven into the shadows, not further stigmatized. And tragically, I do think it's a tragedy because we're talking about the lives of people here. We're not just talking about slogans for elections campaigning or going for some sort of core vote of Conservative Party supporters. This issue transcends partisanship. This is about Parliament being asked by the Supreme Court of Canada to ensure that Section 7 of the Charter of Rights and Freedoms is respected in the way we bring forth laws that deal with prostitution. And on that fundamental requirement of our laws, C-36 stands as a singular failure in that it absolutely will not make the life of sex trade workers more secure. It will actually go in the wrong direction. And as numerous legal commentators have noted, this law will make the sex trade more dangerous. Just to give a sense of why that is, Mr. Speaker, I'd like to quote from the Minister of Justice's press conference on the day that C-36 was tabled back in June. And I'm going to quote an exchange with a reporter. Here's the Minister of Justice, quote, "Some prostitutes we know are younger than 18 years of age. If they are in the presence of one another at 3 in the morning and are selling sexual services, they would be subject to arrest." Question, that would still be considered a criminal offense? Response, Minister of Justice, that's correct. They're selling it in the presence of a minor. Question, okay, so 2 17-year-old prostitutes are standing side by side in the middle of the night in what is considered a public place. They will be committing an offense. Minister of Justice, and selling sex? Yes. Question, that's effectively making them stay on their own and endangering their security. Minister of Justice, oh, not at all. We're not making them do anything. We're not forcing them to sell sex, close quote. Now, that is a response in the absence of reality. If we are to take what the Bedford decision from the Supreme Court said seriously, then we should do everything possible to allow people in the sex trade industry to be with each other, near each other, protecting each other. In fact, they need to be able to find ways. There's this distinction between being on the street and indoor sex work. Anything that drives people in the sex trade industry onto the street and into the shadows is going to make their lives more dangerous. And this goes to the next piece of Bill C-36, which is likely unconstitutional, is banning the advertisement for sexual services and particularly on communicating for the purchasing of sex, in which case Bill C-36 says it's all illegal unless it's a prostitute, sex trade worker, him or herself, who's directly communicating. In other words, you can't publish their ads. That will be illegal. So it again forces a prostitute to lose the intermediary. It forces the sex trade worker to lose the possibility of some form of screening, some way of ensuring they're not face-to-face in the shadows to negotiate their situation. It makes their life much more dangerous. And this was the decision in Bedford. Again, we had guidance on this. The court said in Bedford, quote, "By prohibiting communication in public for the purpose of prostitution, the law prevents prostitutes from screening clients and setting terms for the use of condoms or safe houses. In these ways, it significantly increases the risks they face," close quote. This law is written as though the Supreme Court of Canada gave us no guidance, as though we are blundering around not imagining that the narrow ways in which communicating or advertising can remain legal in Canada, it's as though the Bedford decision gave us no guidance, because what they've come up with is aimed at a new offense of advertising sexual services and is undoubtedly going to make life more dangerous for sex trade workers. Mr. Speaker, I could go on and on. I know my time is at an end. Je veux seulement dire que cette loi ne...
I just want to say that this bill will only make the lives of these people more difficult and more dangerous. Thank you.
Questions and comments? The Honourable Parliamentary Secretary to the Minister of Justice.
Well, thank you, Mr. Speaker, and thank you to the member for her speech. She went on at some length to talk about specific provisions in the bill which would restrict prostitutes from communicating in a public place for the purpose of prostitution. Apparently, she doesn't know that there was an amendment proposed and passed at the Justice Committee of the House of Commons on that very point, restricting the communication in a public place provision to the schoolyard, the playground, and the daycare center. I wonder if she could tell the House if she thinks that it's a good idea that prostitutes be allowed and perhaps encouraged to communicate for the purposes of prostitution in those three places.
The Honourable Member Saanich Gulf Islands.
Thank you. I thank the Honourable Parliamentary Secretary for his question. Of course, I'm aware of amendments that were passed. They have also been judged by those within the legal profession, the British Columbia Civil Liberties Association, among others, as while narrowing the scope, it remains a section of the law that will clearly not survive charter challenge. And it does, and the notion that the use of daycare centers and preschools and so on, I think, is designed to create electioneering and slogans and doesn't pay attention to the kinds of laws we need to pass in this place to ensure that they're constitutional.
Questions
and comments. The Honourable Member for Gatineau. Thank you, Mr. Speaker. And I thank my colleague from the Green Party. Having said that, I'm very pleased to be part of the committee that has studied Bill C-36 in depth. There were several amendments that were judged to be in order, and we were able to debate them, although clearly the government had no intention of letting them pass. But we had an interesting debate nevertheless, because with the goodwill of some of the people sitting on the committee, we were able to minimize at least some of the more negative effects of this bill as it was designed by the government. The leader of the Green Party mentioned at the beginning of her speech
something that would have been in answer to the Bedford ruling. So I would like to ask the honourable member what would have been the proper answer to the Bedford ruling in her opinion.
The Honourable Member for Saanich Gulf Islands.
I want to thank the Honourable Justice Critic for the official opposition, who's done such strong work in so many areas of law in this country. I think, and the Green Party thinks, that the kind of law we need to have is probably closest found in the New Zealand model. The so-called, I expected, by the way, to see something closer to what's described as the Nordic model. I didn't expect to see Bill C-36 with so many areas that criminalize behavior in ways that increase the risk for people in the sex trade industry. But having studied between the Nordic model and New Zealand model, I think that law, which goes the farthest to ensure that the activities in the sex trade industry lose the stigma, that in a sense that we're able to say that someone in the sex trade industry or someone who works for them as either security or scheduling or health care, that those people are not stigmatized. And then we can concentrate on ensuring that people are not, due to addiction problems, being under 19, or foreign workers who have been, and God help us, what a horrific case there is of sex trafficking and human trafficking. Focus on that and eliminate that. Thank you.
Questions and comments? The Honourable Member for Charlottetown.
Thank you, Mr. Speaker. I was a participant in the Justice Committee hearings over the summer on this bill, and we heard from over 60 witnesses. There was a consensus on 3 points. One, that the $20 million that's been set aside for exit programs was inadequate. Two, all of those that were trained in the law, except for the Minister of Justice and those in his employ, felt that all or some of the bill was unconstitutional. And the third was that those involved in the sex trade should not be criminalized. Probably the best suggestion we heard during the course of the testimony was that those who are carrying a criminal record as a result of the unconstitutional law should be given an immunity. So my question for the member is, what does she think of that immunity suggestion, which was rejected by the Conservatives, and any comments she might have with respect to the stigmatization associated with a criminal record as a result of being in the sex trade?
The honourable member for Saanich Gulf Islands, short answer, please.
First of all, I want to commend the honourable member for Charlottetown. I thought his speech at second reading on this bill was the best that anyone delivered in comparing the Canadian laws on prostitution with a made-in-Moscow version for Canada. And I agree that when a law is unconstitutional, we need to look at immunity. And the more that we stigmatize, as much as all of us have our own personal views that come from our own religious or moral context or backgrounds, the bottom line is people's lives are at risk. And who are we as Canadians to turn our backs on them?